And good morning, everyone, and welcome to this week's Let's Talk About. And today we'll be doing just that. We're going to be talking about the rights of grandparents when it comes to their grandchildren. Our weekly Let's Talk sessions, our Just Ask Us sessions, we have two different ones, are supported by United Way, Newfoundland and Labrador, and we're very grateful to them for that support, because we don't know if we would have been able to do it without them. And before we go on, I'm just going to share my screen, and then we'll go through a few little housekeeping points here. Can everybody see my screen? Good? My slides? Fabulous. Okay. All right. I've asked everyone to make sure you have your microphones on mute to block out the outside noises. And I have a cat running around my house. So if I all of a sudden go mute myself, you'll know it's the cat falling. If anyone needs captioning, I've open captioned at the bottom of the screen there. So you can just do that. Any questions or comments you have, I'd be really pleased if you put them in the chat box. Just click on chat at the bottom of your screen, and then over in the bottom right-hand corner, you can write in your comment or your question. Now, at the end, the questions will be answered at the end of the presentation, and we're hoping that there'll be enough time to have, if anyone else has a new question, they can just ask it, okay? And as I mentioned, this session is being recorded. And one other thing, if there are any topics you'd like us to do a session on, by all means, let me know, please. You know, because we'd be only too happy. We want to talk about things that you want to talk about. You know, so if you have any ideas or anything that you ever wondered about, let me know, and we will we'll try to do a session on it anyway. I just want to take a couple of minutes here and to acknowledge the lands that we're living on. We respectfully acknowledge the land on which we gather as the ancestral homelands of the Beothuk, whose culture has now been erased forever. We also acknowledge the island of Uktahunguk as the unceded traditional territory of the Beothuk and the Mi'kmaq. And we acknowledge Labrador as the traditional and ancestral homes of the Innu of Nitassinan, the Inuit of Nunatsiavut, and the Inuit of Nunatukavut. We recognize all First Peoples who were here before us, those who live with us now, and the 7 generations to come. As First Peoples have done since time immemorial, we strive to be responsible stewards of the land and to respect the cultures, ceremonies, and traditions of all who call it home. As we open our hearts and minds to the past, we commit ourselves to working in a spirit of truth and reconciliation to make a better future for all. Thank you. You'll recall that when you registered, I asked you a couple of questions. I just want to tell you what people have said. 60 people responded to the question, are you a grandparent? And that was 60 out of 79, okay? And 38 of the 60 said yes, they are grandparents. 22 are not. The second question I asked was, have you ever wondered if you have rights as a grandparent? And 55 people responded to that. 36 said that yes, they have wondered if they have what rights they might have as a grandparent. And 19 said no, they hadn't. You know, I was thinking about that, and the arrival of a grandchild can be such a joyous occasion, you know, a new little member of the family, someone to carry on the family traditions. Unfortunately, it isn't always the case. Sometimes relationships between a child's parents and his or her grandparents are so bad that the parents refuse to let the child spend any time with the grandparent. Sometimes parents simply aren't able to care for their child. because of illness or addictions. And sometimes grandparents themselves can be a bad influence on a child. I mean, we're not all saints, right? There are all kinds of scenarios when it comes to relationships among children, parents, and grandchildren. And today we're going to talk about any rights that grandparents have when it comes to their grandchildren and the different situations they, the grandparents, might find themselves in. And I am now pleased to present today's special guest. I'm going the wrong way. Greg Noseworthy. Born and raised in St. John's, Greg holds a Bachelor of Arts from Memorial University of Newfoundland and a Juris Doctorate from the University of New Brunswick. A lawyer by trade, Greg works with the nonprofit Public Legal Information Association's Newfoundland and Labrador, or PLIAN, and PLIAN is a very close partner of Seniors NL. We do a lot of work together and refer a lot of people to each other. Additionally, Greg volunteers with several nonprofit organizations, including as a board member of the Canadian National Network for the Prevention of Elder Abuse, a member of the Steering Committee for Seniors NL's Provincial Network for the Prevention of Elder Abuse, an executive director of Food First Newfoundland Labrador, and he is also a director for Nature Newfoundland and Labrador. And in his free time, Greg enjoys hiking the coastal trails along the Avalon Peninsula and exploring our province. And so without further ado, I am going to take my screen now. Greg can put his up and start his presentation. And once again, any questions or comments, just click on chat and put them in the box over in the bottom right of your screen.
Well, thank you so much for that, Mary. I really appreciate it. Can everybody see the presentation?
Yeah.
Good. Perfect. Okay. Yeah, certainly do enjoy hiking. Hopefully I'll get out today as well. It's a beautiful day here in St. John's. And last time I went out last week, I had a couple of falls. It's a bit icy, but I have made sure to take proper boots and poles. That way, once it happened a couple of times, it wasn't going to happen again. So hopefully today will be a bit better and with the sunny and warm weather. But jumping right into it, very glad to be here. Very excited to be with everybody and to provide a presentation on grandparents' rights today. Again, my name is Greg Noseworthy with the Public Legal Information Association of Newfoundland and Labrador. We'll jump right into a couple of things that we're going to cover today. The first we're going to cover is what is the Public Legal Information Association of Newfoundland and Labrador. We'll cover grandparents' rights, and it's a pretty broad topic, but we'll focus in on parenting and custody and access. Those are the big questions that a lot of people want to know about. We'll talk about the dispute resolution process and how to think about grandparents' rights in the legal system today. We'll actually look at some of the court forms that people have to go through as well. So we'll actually get to see some of the things that anybody has been through or is thinking about going through the court system. We'll see some of those court forms that are necessary. Mary, before we jump into it, I'm just going to quickly ask you, how's the audio on my end? Good. Okay. I think I'm going to put these in. Can you hear me now as well still? No sweat? Okay. Because I have these headphones and I think they work a little bit better. Just in case there's echo, I'm going to put those on. All right. So first thing, of course, what is PLIAN, the Public Legal Information Association of Newfoundland and Labrador? We're a nonprofit independent organization. We've been around for going on 40 years here now. And our goal is to educate Newfoundlanders and Labradorians about the law, increasing access to justice in the province. We've got offices in both St. John's and Happy Valley Goose Bay. Our Happy Valley Goose Bay office just opened up this past year. I'm very thrilled to be there and being able to do work in the Big Land. We have a number of different services, including legal education information services such as this. We have a legal information line, which I'll touch on. We provide other resources as well, publications. If you want to reach out and ask me or one of my coworkers a question, you can do that via email or phone call. We have lawyer referrals, sexual assault survivor services, newcomer immigration services, and of course, again, as I mentioned, publication information sessions. Here's an example of a couple of the publications we have. One that's particularly of interest here today is our Family Law Guide for Newfoundlanders and Labradorians. This is the 3rd edition, and this one is a few years old. There have been some changes in court processes, but the law remains substantially the same. And we're currently in the process of editing our 4th edition, which will hopefully be out before the end of this year. In addition to that, we have our Legal Planning Guide, another popular one for folks who are trying to kind of navigate what they want to do with their wills and estates. One of the two of the most popular ones that we have, but we have a full arsenal of different legal publications. If there's ever anything you're curious about, if we have on, feel free to reach out and I'll gladly get that to you. And of course, everything we have is free there. So if there's ever a publication you want, I can either email it to you. And when we are in office, of course, right now we're not. When we are in office, we do also mail out physical copies free of charge. Touching on our legal information line, again, this is if you want to call and just have a conversation with myself or one of my coworkers. We have a toll-free and a local number. This line is open from 8:30 every morning until 4 o'clock, Monday through Friday. We have our email addresses there, the info@publiclegalinfo.com is our general email address. And then the A2J@publiclegalinfo.com. That's actually my email address. And I'll have that again on the screen there in case anybody's taking notes. But if you ever want to reach out to me directly, maybe you had a question, a follow-up from today's presentation, or something else completely different, you can certainly send me an email and I'll get back to you. And we try to get back to everybody within about 24 working hours. We're pretty good at that, of course, unless there's a holiday or if we're taking a day off, which is nice every now and then when we get the chance. Just one quick thing before we do delve into everything here today. There is one key difference with our organization, where we are not government and we aren't legal aid, which a lot of people confuse us for. We're only regulated to be able to give legal information, not legal advice. And that's one of the key differences between us and other groups and firms and organizations. So we can provide clear-cut law. And the example I always use is you had to be 17 years old to make a will in the province. That's what the legislation says. I can tell you right then and there, if you're 16 years old and you come to me and say, Greg, I want to make a will, I'll say, that's okay, but you're going to have to wait because you're not old enough yet. Similarly, I can talk about different family law statutes, legislation, laws, and regulations. I can give you a couple of examples of options depending on your situation. But of course, I can't tell you which one you should choose. That's a determination on your own. And I usually say it's a judgment call. And we can discuss, of course, case law if there was anything kind of wondering about particular cases or how courts have thought of different things. This means, of course, I can't tell you how to complete a legal form. I can't tell you what the best option is. I can't tell you what you should argue in court. And unfortunately, I can't give you my opinion. Now, if you note, I do have an asterisk there on I can't tell you how to complete forms and applications. Again, I try to be as flexible with everything as possible to do the most for people. So if you came to me and said, I'm kind of confused about the forms, and we went through it, I could say, well, this section is asking you what your name is. This section is asking for other parties. This section here is asking what you're looking from the court. So those types of things I can explain, but again, I still can't tell you what you need to put down on the form. Do as much as I can, though, of course. And just a note there, I know Mary touched on it, but I really don't mind questions throughout. So please, if folks do have questions, I know Mary and everybody's keeping an eye on that. So please just ask your question in the chat box. If you're unable, feel free to unmute yourself and just interrupt me. That's more than okay. I certainly want to make sure everybody gets a chance to ask any questions at all. So let's get into that. Oh, one last thing, actually. One of our bigger services, our kind of bread and butter is what we call it, but of course we're nonprofit, so we don't get any money from it or anything that matter. We have a lawyer referral service, and basically what this is a 30-minute consultation for $40 tax in, and that allows you to meet with a lawyer, discuss your legal matter, and get the advice that I can't provide or my coworkers can't provide. Great thing about it is there's no obligation for you or the lawyer to go beyond that. So if you just want the 30-minute ask a question and kind of go on about your business, that is more than okay. There's no issue there at all. And this is available across the whole of the province. Don't have lawyers in every town, but we have lawyers who take phone consultations. So we've made sure that everybody can access this, no matter where you are in the province. Even people in Ontario, Alberta sometimes call us, and they're looking for information on questions about the law in the province, maybe because they have parents here or they have a house here or something. So we even provide those referrals as well to people outside of the province. We've got about 60 lawyers on right now, which is pretty good. We're always looking for more, and we're always expanding that. And it's a great service. It's a great way just to get some basic legal advice without having to go too deep into hiring a lawyer or something like that. And then lastly, some of our other services, and I won't touch on these too much, but we have a couple of distinct services for folks, whether they've gone through sexual assault, they want to learn more about that, or maybe someone's a newcomer or an immigrant to the province, and they want to learn more about their rights. And that service is available in both English and French. And of course, what I provide also is in both English and French as well. Try to make everything as accessible as possible to everybody as possible. But that's PLIAN, the Public Legal Information Association of Newfoundland and Labrador. Unless there's any questions on that, we're going to jump right into grandparents' rights and the rights of a child. So this is an interesting area, and Mary and Barbara and myself were chatting just prior to going live here today. And, Mary, of course, noted that the vast majority of folks on the presentation today are grandparents. And it is a very interesting area of law because it's becoming a more and more talked about area within family law itself. We're seeing more and more applications come to the courts within the province. And I think generally we're seeing more and more people come to the courts as they're able to access information and learn about the legal system itself. Of course, with accessible internet and technology at home, everybody is able to look up things. So the more we have that accessibility, I think the more we'll see these sorts of applications. And of course, this is becoming a bigger area, and that's why we're here talking about it today. So let's jump in. One of the first things we should touch on is kind of what I'm calling the changing tides. As I mentioned, we have our family law guide, and although it was only produced in, I think it was 2013, 2014, which is only 7 years ago, there have been a number of changes in the law since, and a couple of changes both legislatively and within the common law, which is judge-made law. A lot of times we used to refer to children in light of custody and access. I'm sure everybody's heard about whether a person has custody of a child or if they have access to a child. And this is kind of the old way of thinking about things. Now, everybody knows what you mean when you say that, but it's kind of an old way of thinking of kids as being something you controlled or you owned, which of course isn't the case. We don't own people. Now we've changed our language, we've shifted our language away from custody and access to parenting and parenting time. And this is exactly the same thing. There's no real substantive difference. It's more just a different way of thinking about things. Because of course the law is a living beast, just like a language or a society. It changes with time. Things ebb and flow, and so do the terms we use within the legal profession. So you might come across, when you're doing research, custody and access, you might come across parenting and parenting time. It's the same thing, so don't fret too much when you see that. Another great note there, Mary just put up as well, is that the new language also shows respect for the child, and I couldn't agree more there, because again, as we'll see, family law is concerned with the children, and they are the paramount concern when we're talking about grandparents' rights, parents' rights, or anybody's rights. So jumping now into the access and parenting side of it all, it's a fundamental piece of family law. And really and truly, when we talk about, oh, got back one. There we go. I managed to make it pull back up. It's the magic of the internet. Access and parenting is really and truly a fundamental piece of family law. When we think about family law, there are some big headers, big points, whether it's divorce or child support or spousal support, sometimes called alimony. Parenting is one of the biggest ones. Anytime there is some sort of a divorce application, first question that a court or a lawyer or anybody involved in the proceeding wants to know is whether or not there are kids involved. Because if there are kids involved, we need to figure out what's going to happen with them first. They're our biggest concern. And the reason they're our biggest concern is because children can't support themselves. Until they get to a certain age, until they become an adult, they are dependent on adults to get through their day-to-day lives. And whether that adult is a parent, a grandparent, an aunt, or an uncle, this is huge. We'll touch on now a bit of how to view access to parenting. And we'll touch on the most fundamental piece, the most important thing we'll discuss today, the best interests of the child. So thinking about access and parenting, and always I get this question. I mean, it must be sometimes 3 or 4 times a day, just between emails and calls and presentations like this. What are my rights? And it's such a broad question. It really, truly is. It gets so tricky so quick. And I really think that it might not be the best approach to understanding access and parenting. Again, as we discussed a minute ago, we're concerned about the child, concerned about the best interests of the child. And access and parenting of a child is really and truly the right of the child, not the right of the parent and not the right of the grandparents. Courts have time and time again, no matter what level of court, no matter what province we're looking at, they understand that it's important and it's beneficial to have family members in a child's life as they are raised and brought up, provided, of course, it's in their best interest. Of course, if we have somebody who is unfortunately involved in some criminal activities, maybe they're an alcoholic and things like that, it might not be the best interest for the child to have that person in their life, that particular person. But as a general rule, when we think about the child, we recognize how important it is for a wide variety of people to be in their life, to play a role in helping bring them up to become a functioning adult, really. So when we talk about access, when we talk about parenting, we really need to shift how we think about it as my right, the right of a parent or the right of a grandparent. We should really start thinking about as the right of the child. So it's the right of the child to have parents in their life. It's the right of the child to have grandparents in their life. That's the sort of discussion we should be thinking about. It's very much the same thing, but it's just a different perspective on it. And the reason we should think about this is because courts are so concerned with this best interest principle, which I kind of alluded to a second ago. It is the guiding principle in family law proceedings involving a child. It is the most important consideration. Whether that's child support or otherwise, we want to make sure that no matter what happens, the child is going to be taken care of. Because again, they can't take care of themselves. The thing is, and this is probably the most difficult thing, and anybody who's gone to a lawyer or asked somebody in the legal profession their opinion on something, usually I find you get the unsavory answer of, well, it depends. And that's basically a lawyer or a legal professional saying, I don't know what the answer is because each case is different. And really and truly, the best interests for a child vary from case to case. What might be the best interest for one child in St. John's certainly might be different in St. Anthony or in Nain or in Burgeo. Everybody has different needs and everybody's going to have different interests. And of course, that's going to impact how this is interpreted. I do want to just draw our attention to the best interest of the child from the Children's Law Act. It's a great way, I think, to kind of see the actual thing here in play. So Section 72 of the Act says, in a proceeding before a court where the custody or upbringing of a child, so where the parenting or upbringing of a child is in question, the court, in deciding that question, shall regard the best interests of the child as the first and paramount, the biggest, consideration, notwithstanding whether the claim of the father or the right at common law possessed by the father in respect of the custody or upbringing is superior to that. I never had to move, part of my screen was blocking that, of the mother, or the claim of the mother is superior to that of the father. It's basically just saying, look, it doesn't matter whether you're the father or you are the mother. Ultimately, the thing that we have to look at is the best interest of the child. It's the most important thing. And the court has to take an eye to that. And that's same too when we're talking about grandparents' rights, as we'll get into more here today. So I think one of the things on this discussion, continuing this discussion on the best interest principle, we should continue to look at the Children's Law Act as a good piece of legislation to get an idea for this. We're talking about actually making an application for custody or access, parenting and parenting time. These are some of the things that courts look at. And this is just one piece of legislation and probably one of the more common ones that you'll see as a grandparent. You wouldn't see this come up as much with divorce proceedings, for example. But I think it's important to look at in determining, and this is section 31.2 we're looking at here, in determining the best interest of the child for the purposes of an application, the court shall consider, so they must consider all the needs and circumstances of the child. This includes the love and affection and emotional ties between the child and the persons they list out. Each person entitled to claiming custody or access parenting time, other members of the family, persons involved with the care and upbringing. I mean, that one's very obvious that it can include grandparents. It can also include uncles, aunts, people like that. This one's interesting. The views and preferences of the child, because of course, as children get older, they start to develop more and they start to have a bit more of a better understanding of their situation. So what they have to say becomes an important consideration. Provided, of course, and you see there, provided, of course, that the views and preferences can be reasonably ascertained. The length of time the child has lived in a stable home environment, that's another big one, because of course, that's huge for whether or not a child is having a healthy upbringing. The ability of parents to seek a custody or access application, plans for the proposed care and upbringing of the child, permanence and stability of the family, the relationship by blood or through an adoption order. It goes on. There's a number of considerations here. And I think really the key thing that we need to take away from this piece of legislation is it's a very broad thing. Best interests are extremely broad. And if we go back to the idea of each case will be different, the best interest will be different in each case, really and truly. There might be a situation where one grandparent was responsible. It feels like a Monday here when I'm trying to get sometimes some to get this something out. Sometimes the court is going to consider whether or not a grandparent was responsible for bringing up a child for the first 5 years of their life. So obviously, if that means that one grandmother, say, had the child in their home and the child was living with them from the time they were born up to age 5, that person has stepped in place and been a stable, permanent family unit for that child. And that is something that the court needs to consider when somebody else comes along and says, well, I appreciate that you've done this, but now I want to have some parenting as well. And the court has to grapple with that issue. Is it good now that we take this child and maybe make the custody and access to parenting time 50-50? Do we do that? Is that appropriate for the child? Or is it more appropriate to leave the majority of time with the grandmother that the child has been with for their whole life? So there's those types of things. Then we have to consider, is it the parent that's trying to get parenting time and custody or access? So there's all those considerations. And then of course, as the child ages, like I said, right when you get around age 12, 13 or so, and a child has, they're around that teenage years, they start to be able to make some rational choices. Although sometimes it certainly doesn't feel like it, I'm sure. The court's going to say, well, what do you want? What do you think is best? And sometimes that might be staying with Nan. Sometimes that might be staying with Pop. It could be something like that. So those are important considerations. And we see this expressed more and more as children get older, of course. But again, the key thing to take away from the best interest principle is that it varies from case to case. Every situation is different. So for everybody's situation, if anybody on the call is on for their own personal situation, your situation, I would never be able to say, because until we get to that point when we go before a court, you just don't know, really and truly. And that's kind of an unsavory answer, I know, but it's important just when we're understanding how these things play out. Mary, do you have any questions coming in there right now, or? Perfect. And certainly, folks, don't feel shy or that you don't want to ask a question. And we won't call you out if you send either myself or Mary a question privately. We don't have to name you, so don't worry about that. And if I am going too fast, or if anybody wants me to repeat anything, please let me know. That is more than okay. Continuing on with the best interests, and I think we're starting to see a theme here that this is a really important thing to think about and really trying to hammer home that to everybody. This is Section 25 of the Children's Law Act. The purpose of custody and parenting under the Children's Law Act is to ensure that application to the courts in respect of custody of, incidents of custody of, and access to children will be determined on the best basis of the best interests of the children. And I think that sums up really well that this is the most important consideration, the paramount consideration, as we've already seen. Shifting, because I know this is the big question that everybody's wondering: can a grandparent apply to court for parenting time, the access? And the answer is yes, of course. There's no doubt there at all. That is 100% a possibility. And not only that, anybody with a demonstrated, settled intention to treat a child as their own family can apply to court for parenting time with a child. But of course, remember again, that best interest principle is going to be the guiding thing when we're talking about these legal matters. And I think if, just to hammer home that, it really can be anybody. I mean, let's say, for example, that I have a nephew, right? So I'm his godfather, he's my godchild. And let's say, God forbid, I'm going to knock on wood because I'm talking about myself, something happens to me, and my girlfriend, she's not married into the family, and we don't have that blood connection, of course, between him and her. Maybe because she's been close with him, she needs to make an application to the court. There could be some situation going on there. She could be the one that has that demonstrated, settled intention to treat a child as her own family. So she could even come before the court. Then, of course, we have grandparents, which, we're talking your own flesh and blood. That connection is very apparent there. So we keep that in mind. I think, too, if we're talking about, a lot of times people now are getting partners later in life. And if you have a common law partner, unmarried partners, as we like to say a lot of times, who isn't part of the family by blood or marriage, they could also be involved in some of these proceedings. Well, let's look at specifically Section 27, and this is coming from a different section, Section 69 of the Children's Law Act. This allows for specifically the following persons to apply for parenting. It's listed here. So obviously the mother and father, someone with that demonstrated intent, like we said. A grandparent is listed. It's the third one. It's very clear in the legislation that under the Children's Law Act that this is a possibility. So that right there, I think sums up very quickly that a grandparent can apply to court for parenting time of a child. And then, of course, number 4 there again, someone with the actual parent upbringing of a child immediately before a court application. This one I've seen kind of used, again, when you deal with family-friend situations, I've seen that kind of happen when someone might be in a smaller community and there's no option for somebody to help within the family care for somebody. So let's talk about actually applying to court for parenting time. Let's talk about that, because I think that's another good consideration. If we know that we can apply, and we know that that's something we want to do, we should probably have a good idea of what that looks like before we actually jump into it. Don't want to jump right into the deep end. We want to kind of wade our way through the shallow end first and let the water get deeper and deeper slowly. So the first thing you got to do is determine which court you're actually going to apply to. And there's a number of different levels of court within our province. Within the St. John's area, as far as Holyrood, and within the Corner Brook area, you're going to be applying to the Supreme Court Family Division. Happy Valley Goose Bay soon will also have that set up as the default to their Supreme Court Family Division. But a lot of areas in the province are restricted to provincial court. So keep that in mind. And there are some areas, depending on where you are in the province, that you can apply to both. Now, I do have a question coming in here, so let's just take a look at that. So, what are my rights to my grandchild where the daughter-in-law dislikes me and has poisoned my son for me? There's a child that I'm not permitted to see or have FaceTime with or send gifts to. They blocked me out of the child's life. I know if I interfere, the daughter will poison the child for me, which of course continues the issue. Will I ever get to see my grandchild? It's been 5 years before contact. So this is one of those things, and really, and just to restate it again, situation where somebody's been alienated from their grandchild's life, and as a result of their daughter-in-law or their son-in-law, whoever. And of course, then that perpetuates within the family, and your own child has kind of taken that stance as well. It's a tricky beast. You certainly have the ability to apply to court. There's no doubt about that. I can tell you that 100% any day to Sunday. Question you have to grapple with, and we'll see this through when we get into the dispute resolution process, it's kind of more the practical side of things. It's fine and well to go to court for any issue, really and truly it is, but you always have to consider the practical things. And that's not to discourage anybody from going to court. Sometimes it might be at that point that's the only option. But the reality is sometimes any hope of rebuilding bridges could be squashed by starting a court application. Court is a bit of an intimidating beast for a lot of people, and even just for somebody who's making an application themselves. The person on the other side is going to be served with court documents. They're going to have to do all these things as well, and of course they didn't ask for it. So they're going to be just as intimidated as you. It really is a judgment call. You certainly can make an application. Don't think you can't. Don't let me dissuade you from not or from doing. It's a question, right? As we'll see when we get into some of the dispute resolution process, the court first requires certain steps for mediation. So the reality is sometimes that can cool up things very quickly and easily. But we'll get more into that as the presentation goes on. But yes, you certainly could apply, so keep that in mind. But again, keeping in mind, first thing we got to figure out before we do anything, we got to figure out what court we're going to, because there's a provincial court, there's a Supreme Court, there's even a Court of Appeal, which is different again. So we need to think about where we are in the province and which court's actually going to be the one we're going to. Now we're going to touch on applying the Supreme Court Family Division, and this very low resolution photo of the Supreme Court here is the Family Division on Portugal Cove Road there in St. John's, at the corner of Elizabeth and Portugal Cove Road. So the first thing we got to consider is our filing requirements, what we actually need to get into the court to get our court date, so to speak. First thing you need is what is called an originating application. And if you notice, I have that up on the screen. This is actually the first page of an originating application. So we'll look at that a bit here. Once this is completed, someone then must serve the other side, whether that's you or the lawyer, right? Someone needs to serve for you, rather. So again, this could be an adult of age, it's a friend, it could be a lawyer, it could be a courier. There are professional service providers. They are called process servers. They can be expensive. I will say that right off the bat. Law firms usually employ these folks, and if they try to serve somebody and they were unsuccessful, you're still getting charged. You'll get charged for the second and third attempt as well. So keep that in mind. Figure out the price for services, the fee for services before you agree to do that. After the person on the other side, so presumably, whether it's the mother or father of the child or whoever it could be, of course it could be an aunt or an uncle. After this person has been served, that person who has served for you should complete an affidavit of service. And this basically is just a sworn document that says, yes, I served such and such on this day. It's basically just letting the court know that, yeah, this person knows that this is coming. Because if not, that's certainly not fair for them. Just taking a second here to look at the form. So there's a lot of stuff here that looks intimidating, but there's a lot of stuff here you don't need to worry about. At the top here, it just lays out, this is the originating application. It's just the title. Underneath there, it has this nice big block, which is about 10-15% of the page that you don't have to touch, which is great. That's only for the court registry staff. So that's fantastic. And then you see there, it just says between the applicant and the respondent, and potentially another respondent or another applicant. That's simply just filling out names. There's nothing crazy there. And the great thing about these family forms at Supreme Court is that there are instructions on the forms. So they make it accessible that way. It doesn't cover every question you have, and I know that just from experience from chatting with people, but it does cover quite a bit. And as we touched on a second ago, first thing you got to figure out is where you're going to go, which court. And it says right there, you must start your application at the court location that is closest to you or closest to the other party. right? And then it goes on to talk more about it. And then it's just a matter of checking which one. So whether that's checking Happy Valley Goose Bay or Port of Ass, Rocky Harbor, it's there. I always say this about any court application. At first, it's always daunting at the sight of it, but it's no different than looking at Signal Hill or the walk to the mailbox some days when it's snowing out. It looks daunting at first, but once you take a couple of steps, you slowly get there and you get to the top, you get to the finish line, and it's done. And then you can actually file. So don't get discouraged when you're looking at something like this, even though there can be a lot of pages. Just take it slow and take your time, read the instructions. If you have a question, give me a call or one of my coworkers, and we'll gladly help you out. And as you'll see towards the end of the presentation, we have a free program you can use to help actually complete these forms. Touched on the affidavit of service. Again, for folks who don't know what an affidavit is, it's just a sworn document, sworn outside of court, basically saying, look, I swear to God, or I affirm that this is true to the best of my knowledge, of course. This can be done by a commissioner of oaths. Court registry staff are commissioner of oaths. They have been doing this in the past where they would sign these things prior to filing. Of course, with COVID, they're not doing that. And that's kind of thrown a bit of a wrench into that. So you will have to find somebody who is a commissioner of oaths. If you know anybody who works within provincial government, every single provincial department I'm aware of has a commissioner of oath on hand just for things like this. Whether it's signing something for a pension or whatever, or you just want to ask your friend down the hall to help swear you on the document here. Could also be a notary. We don't have a listing for notaries. They are unlisted. I myself am a notary, for example, but you won't be able to find a registry of notaries. A mayor of a town, they can swear. That's completely fine. That's under our legislation, allows them to do that. Lawyers, by being virtue of being a lawyer, they have the ability to do it, or someone else with another ability under legislation or otherwise. And like I said, you're just swearing to God or affirming that what happened is true, and that's it. Nothing too crazy. And the court has this affidavit here for you, Form F8.03, Affidavit of Service. Again, if you know, and if you notice there, it has in the big square, again, section that you don't have to worry about. You list your names between Greg and Mary. Sorry, Mary, I'm serving you. And then you just fill out, I declare that I, Greg Noseworthy of St. John's, served Mary Ennis on March 24th, whatever today's date is, at St. John's with a copy of the following. And then I just check off what I served her with, and then how I served her, whether that was personal service or otherwise. It's not that complex when you actually get into it. I know it looks daunting, but it's not too bad. So we've filed our originating application. We've got that sorted. We've served the other side. We've got that done. Court's aware of that. Now what are we doing? Once we've actually successfully filed our originating application, served the other side, and filed that affidavit of service, you'll be given a court date from the court registry. Of course, now just to give some practical information, there are some delays with that, of course, with COVID. And usually on a good day anyways, you're looking at 4 to 5 weeks out, unless there's been a date that's opened up for some reason, whether a trial is canceled or something. Usually I always tell people, be prepared that it's a month or so out. And be prepared to wait a bit just to give the registry time to catch up on what they're doing. They, of course, deal with a ton of work. So give them time to actually catch up to your file and get you a court date. And they'll notify you. They're really good at notifying people, whether that's like a call or sending out a letter. And if there's ever updates too, they are great for contacting you to let you know. I, for example, one time was going through court and I had court registry call me the day before just to make sure everything was still fine. So folks there do a good job of making sure that the processes run as smooth as possible. But your first date that you're going to be going through the court process is for what we call mediation, which I alluded to before. And basically mediation, all that is just an opportunity to kind of sit down and try and resolve the discussion or the conflict between yourselves and an independent third party. This will go through when we're talking about children, of course, we'll go through family justice services. And this is pretty much all family justice services does, or at least the majority last time I checked. again, it's a great opportunity for people to come up with their own resolution and they can agree on something together. The thing with going to court that a lot of people have to debate on, and again, this is why I always say it's a judgment call when you're doing these things. You know, you're rolling the dice. If you are adamant that you're not going to agree with this other person, this other party, and you go through family justice services and you're putting your nose up to them just because, the judge can make a decision on what they see as best. But the judge doesn't know the full circumstances of the situation. They don't know the 20-year relationship between a parent and a child. They don't know these things. So I always say, of course, you have a bit of control in your own proceedings, subject to coming to that agreement, no doubt. But you have that ability to kind of resolve the matter for what's best for you as well. Never mind just what's best for the child, best interest of the child, but think about what's best for you guys. That might be something that a judge just doesn't think about. Maybe they aren't thinking about the FaceTime thing. Maybe they aren't thinking about, in the summer, little Joey goes out with Pops on the boat fishing cod. Like, he doesn't think about this. He doesn't think about this. So these are things you can include in your agreement, your settlement, your parenting plans, your custody plans, your parenting times, all that. So keep that in mind. You can get really flexible there too, which I think is huge. And the best thing about all this is that mediation is a very quick process, much more quickly proceeding than going through court. If you're waiting to go to court, you've got a number of different steps, which again, we'll get into here. But there's preparation of documents, there's actually setting up trial dates and all this kind of stuff, meeting with the judge to make sure you're prepared for trial. So mediation is a great thing. I know it doesn't always look great, but it's a good opportunity to resolve this problem. Mary, do we have any questions coming in there? And I'll just, I'll prompt again there if anybody has any questions. Get my tea here. We're good on our end?
Yep, that's fine.
Perfect. And again, folks, don't be shy, please, really and truly. We had a couple of questions that were submitted before the presentation. We'll answer those at the end of the presentation if anybody is curious about your question. But don't hesitate to let me know or save it till the end. So Family Justice Services, because I mentioned them, you're probably thinking, oh, who the heck are they? Family Justice Services is just a division of the Department of the Supreme Court. They offer a number of services to help families resolve custody access, parenting time issues, including child support issues outside of court. Again, as I said, court is very busy. There's a huge backlog, and if you can resolve your process through Family Justice Services, acting as a mediator, I think that's great. Everything they do is free. That's the other great thing. Everything they do is free with residents of the province, involved in family law matters, and a couple other things, right? Just note there on what they provide. In addition to acting as mediators, they also provide education sessions on family law and parenting after separation, because that might be when your questions at it. As a grandparent, where are my rights lie now that my child is divorcing from their partner? What happens then? They also have counseling services for families to help navigate processes as well and bigger issues. So they're really a wonder of a service, and certainly recommend checking them out if that's the path you're going. And you're going to have to actually, because it's mandatory. So that's the first thing too. But what happens when mediation fails? So you've gotten in the court door, you've got everything served, you're trying to go through mediation, mandatory process, but nobody's agreeing here on anything. It's not coming out the way you want it to. The thing with mediation is it's not formal court, and parties aren't required to come to their own resolution. They don't have to participate. They're supposed to participate, but the cops aren't going to arrest them for not participating in mediation and coming to an agreement. If this happens, and it does, don't panic. It is an unfortunate reality. It is a normal part of resolving some disputes. When this happens, the court is actually going to set down a case management, which is a bit different. And this is the second step. We've gone through filing everything. We've got our first step with Family Justice Service mediation. That hasn't worked. We're going to the next step, case management. So slowly getting the lines open there. Case management is a pre-trial meeting between parties, so disputing parties, and a judge to help manage pre-trial matters related to court applications. and or trial if we're getting to that stage. Case management allows parties to better understand what are the issues that they're going to face. Whether that's, you got to be prepared to bring witnesses, you got to be prepared to talk about, maybe you already have some kind of these sorts of things. Making arguments on what is the best interest of the child. And the goal of case management is to create a smooth court process and really to keep things from going to trial, but to handle as many of those issues beforehand that can be dealt with beforehand before you actually get a trial date. So that's another key thing. And you're sitting down with an actual judge in this, right? So the thing I always say with that, judges are great. They see this all the time. They know what they're doing. They can make orders in this situation though. So there are times where people, again, don't participate in this, but if that's happening, a judge can make an order, and they can make an order if the other side isn't there. So keep that in mind as well. So it's not a trial, right? It's a bit different than a formal courtroom setting. It's not open court, so people aren't going to be coming in and looking and listening to you, gossiping or anything like that. But a judge does have that power again to make that work. It's much less formal. You're just going to be sitting down, kind of like you are right now, having a discussion, figuring out what needs to be done. And it's a more relaxed way of handling court processes. But again, and I'll repeat that again because I always like to make this point a couple of times. Don't forget that judges still have powers in case management to make orders as they see fit. And I've heard of that happening. I've seen it happen. So don't be don't slack on it, I think is the best way to put it. It's still part of court, and the court still has the power to do what needs to be done to make sure that justice is seen. This one's a bit more daunting, I always say, because you are with a judge. Your heart will probably be going a little bit quick when you're getting ready to go into your meeting. So we'll touch on what to expect. Once your case management hearing is scheduled, the court, of course, again, is going to notify you and the other side, whether that's their lawyer or them themselves, about the case management hearing. Anybody who's going through a case management hearing must be prepared, though, and they must attend this. So again, if they don't attend it, this is where judges sometimes might just say, you know what, you've missed 3. The other side is trying to do stuff here. They're not asking for anything unreasonable based on what I see. I'm going to make it work. And that's the reality. Although it is less formal than court, it is a court date. Keep that in mind. And more practically, again, I always like to bring up the practical side of this. Normally, people are going to go through a few case management hearings before they actually get to the resolution process, because there's going to be a number of things. Judge is going to say, well, I want you to get this next time. I want you to get that. And next time, hopefully those things will be sorted. And if not, it's a matter of getting the homework done again, or maybe there's more homework to be done. And usually there's about a month or so in between each of these, just because the court has so many cases. So being honest, this can take up to a year or more, depending on how things go. And again, parties can resolve these problems themselves still up to this point if they can come in and say, you know what, Judge, this has been great, thank you very much, but we came to an agreement, we're satisfied, we're going to withdraw our claim here now. And that's great, and that's what we hope, really. Sometimes, of course, that is not the reality, though. So your case management hearing will be at the Supreme Court with the judge, or a justice, as we call them at Supreme Court. There are judges at provincial court, justices at Supreme Court. Again, it's a private matter. The public will not be coming in and gawking at you, so don't worry about that. Your case management hearing might be very brief. It might be in and out within 5-10 minutes, depending on the needs that need to be addressed. And be prepared that the first case management hearing probably will not resolve all the issues. You'll have another one or so. The key thing here that the judge is doing with these case management hearings is they're alerting each side to issues and what they need to be prepared for, particularly if it comes to the point of trial. And this might be including filing certain documents and having certain documents ready to go. So again, you've got to have any of your tasks completed after that first and after that second and third hearing. The judge will tell you your homework and you got to get that done. If you have any new or additional documents that you haven't filed, you got to get them to the registry at least 7 days before your next scheduled case management hearing. So, and the reason we have that rule is to make sure that, of course, the process is fair for everybody. They have time to look at it and actually kind of think about it and get prepared for what they're going to say. You also had to serve the other side again if you have new or additional documents, and that has to be within 7 days as well before the case management hearing. The golden thing with anything, if you know you're going to bring it up and you're 20 days out, why not just get it done then and get it out of the way? Don't wait until day 7 and all of a sudden you have a flat tire and you can't get it done, because that is a very unfortunate thing. Of course, I'm sure everybody's wondering, okay, we've done the mediation, we've done the case management. Those haven't worked. What happens now? Well, if that's unfortunate for one, and if that's the unfortunate reality, the next step is going to be going to a formal trial. Keeping in mind, of course, you can request a trial if you feel like that case management hearing is not working and that you want to go to a trial anyhow. But you have to go through your first case management hearing at a minimum before you can do that. And your request for trial form is going to include putting down different information on witnesses, whether that's calling people or not, who would testify in trial, among other things. You might have to participate in other hearings, and one of the most common being a trial readiness conference. And this is just basically a judge again sitting down and saying, okay, where's everybody at here? I'm not going into court wasting court time, valuable court time, when you guys don't even have your witnesses ready. They're assessing preparedness for trial, right? So that's often a thing that comes up as well. I say this, and again, I say this only because it is more of a statistic than anything. It's less common to proceed to trial for a parent against a grandparent. It certainly does happen, it can happen, but I think it's just more of a statistic fact because it tends to be that parents are the ones who are going through court for parenting orders. And one other important note I think is key is that your request for trial can be denied. The judge doesn't have to accept that on first go, right? So keep that in mind as well. You can't just try to blindside catch somebody and go straight to a trial. You got to participate in the necessary steps. Well, let's jump into the trial. So what is a trial? It's certainly not Law and Order. It's certainly not what we see on Perry Mason or anything like that. I'll guarantee you that. It's quite a bit different. I think TV has skewed our minds to what trial is, getting up and trying to grill somebody on the stand and trying to get them to admit something or anything like that. It's a lot more tame, at least on this side of the border. But it is a formal process with formal rules and procedures that have been followed. So that's one of the key things. One thing we don't touch on in this presentation, and again, if anybody has any questions on this or anything else in this presentation for that matter afterwards, you can always reach out and chat more privately. One of the guiding things with any trial going through Supreme Court Family Division is, and provincial court as well, is there are court rules that have to be followed. So keep that in mind. These rules are there in place for reasons, and you can't just decide to ignore them and try to pull a fast one on somebody. You have to follow the rules. And a judge will remind you when certain things are not allowed to be said or done in court. Trial includes, of course, presenting evidence through witnesses and affidavits or other means. Anytime we're doing anything in court, we have to find a way to give our evidence. That might be by saying, I pull Mary up on the stand and I say to Mary, now Mary, you know Barb, you've known Barb for however long. Tell me something about whatever's gone on with Barb and the child or something like that. That's a pretty bad example from a lawyer's perspective, but it's that idea of using Mary as a tool to haul out information to build my case. Maybe it's in taking what Barb has in an affidavit, and Barb has said A, B, C, D, E, and Mary verifies A, B, C, D, E as well on her own side because maybe she was at something. So you bring up your evidence in different ways, and if you don't have evidence, well, you don't have a case. And if you don't have a case, writing can be on the wall. Again, judges are really good, especially when we're talking about these sorts of things, because the majority of, well, I shouldn't say the majority, but a lot of people go through without lawyers or end up without a lawyer at some point, and they're doing it themselves. So they will help guide people as best possible. Key thing here is the best interest of the child is going to be what we're focused on. Again, it comes down to this best interest, whether it's at mediation or it's at the case management hearing or it's at trial. That's the thing we should always be thinking about. The best interests of the child. What are the best interests of the child? And showing that it's in the best interest of the child that you have parenting time with the child is what you're going to be arguing, of course. And you have to prove that on a balance of probabilities. I'm sure everybody's seen that classic scale of justice, the lady with the blindfold holding the two scales like this. I mean, balance of probabilities means tipping the scale one way more than the other. As long as you've proven your case 50% plus one, more likely than not that it's in the best interest that the child be with you as opposed to the other person. That is how a judgment can work. So that's what our standard of proof is, our burden of proof, balance of probabilities. Again, and just to sum it up here, for grandparents, this may mean proving that it's in the best interest of the grandchild that you have parenting time with them, as opposed to not having that time. And after both sides conclude their points, because again, of course, both sides are going to get the opportunity to speak here, the judge is going to make an order determining what will happen and how it's going to happen. So keep that in mind. Once you get to this point, it's out of your hands and it could go the complete opposite direction that you wanted it to go. Bear that in mind. That's always the And Mary just asked anybody if there are any questions. There's our Lady of Justice here, if anybody was trying to visualize. So jumping into this, I always think this is important, just kind of the advantages and disadvantages of this system. Our legal system is designed to facilitate people to come to their own dispute resolution. That's what we want. We don't want people going to court. Courts already have enough to do. They really don't need more people. The work is there. They're not going to lose a job. I guarantee you that. Mediation and case management hearings are ample opportunities for people to agree for what is best for a child instead of just having a judge decide that for them. I always say this too, because I've seen this take sometimes years, and it's an unfortunate reality. Don't get me wrong. It's a slow grind. Takes time for matters to be addressed, and it can be really daunting at times and frustrating at times, but the system is effective, especially once the agreements or the court orders are in place. It works very well. Just keep that in mind. There's always that light at the end of the tunnel. Another point to all this, of course, is, what if you change your mind throughout any of these things, whether it's the mediation, the case management hearing, or anything like that? Now, if you change your mind partway through the proceedings, you want to say, what, I don't want to do this anymore, you can. If you're in the middle of a trial, unfortunately, I think that's a bit too late. But if you decide that, after the first mediation session, what, this probably isn't in my best interest, never mind the best interest of the child, I'm going to withdraw my application here. And that's okay. But again, keep in mind that in some situations, you might not have that option. Middle of a trial being one of those ones where people try to do that. Someone just asked a question if we can get the slideshow after, and that's fine. That's no problem at all. I think, Mary, I'll give the presentation to you, and then you can pass it out to folks who need it. So certainly get that out. And if anybody has any specific questions, don't sweat it all. Again, what if you change your mind? What if you and your child or the parent or whoever it is, the guardian of the grandchild, come to an agreement to resolve it? Again, you can both retract your claims and your issues with each other in court and just resolve your problem there and go on about your lives. So that's great. One thing though, if you've got court documents in and you do change your mind, you've got to let the court know. Don't just stop showing up. You got to tell the court. Especially for their own sake too, as well, just so they know that, okay, we have another hour here for you that somebody else can take advantage of. I think that's important as well. So notify the court if you are going to change your mind and pull your application. So this is what I like to call the Reader's Digest takeaways. It's really best to view parenting as a right of the child. Again, I think that's a different way of thinking about it. I'm sure a lot of folks are kind of thinking to themselves right now, geez, yeah, I haven't really thought of it as the right of the child to have me in their life, as opposed to the other way around. It really is the right of the child to have grandparents in their life. Because again, we're looking at that best interest principle. And the best interest principle is paramount. It is the number one most important thing that we are concerned with when we're handling any kind of parenting proceedings. Again, keep in mind that we've shifted the language. I don't have this as a takeaway here, but keep in mind that we shift our language as well to parenting and parenting time versus custody and access. The resolution process as well, it's a multi-step process. It takes time. There's legwork involved. It's like anything. You want anything in life, you got to work for it, though, unfortunately. One thing I always say this as well, a lot of people get frustrated with the justice system. They have an issue going on and nothing's happening about it. Well, the one thing I always like to say that is a court can only do something when they know it's actually happening. I mean, a judge can't be walking around looking for injustices everywhere. You have to actually file something with the court. And if you don't file something with the court, they're not going to know. They're not going to be able to do anything about it. So our system is application-based in that sense. You have to bring something before the court if you want something to happen. So keep that in mind. If you're attending this presentation and you know that people are going through this and they're having their issues, again, I know it's frustrating for someone to have to be told you got to go through court, but that's the system we have. That's our resolution process, and sometimes people don't want to go through it. That's okay, but this is the way to resolve things if you can't do it on your own. But if you can, I think most important part here on this Reader's Digest, if you can resolve it, you should at least consider resolving it together without going to court, because you together can decide what is best for the child. Leaving it to somebody else who doesn't know you from Adam isn't always a savory thought. A judge can only do, again, what comes before them. And if you forgot to tell them something in the middle of the trial, unfortunately, that's it. You had your shot. So keep that in mind. So before we get into the questions, we do have registered. This is one thing I want to let everybody know. We have a family form builder, and the little picture on the bottom, that is actually part of the screen you'll see when you go to it. It's a free to use program. It's completely free. Again, we're a nonprofit organization. Our whole goal is helping people and expanding access to justice. So what this form builder does, basically you go on, you register, you put in your email, you create a username and password, and it'll ask you questions. What's your name? Who are the parties involved? Those sorts of things. And based on your answers, it'll actually fill in the court forms for you. Keep in mind, if you answer a question wrong, it'll do a poor job on the court form. But as long as you're answering those questions correctly to the best of your ability, it will generate the necessary court forms. And then you can bring it to provincial court. You can bring it to Supreme Court Family Division. The link right there, publiclegalinfo.com. That is our website. And then you'll see a tab there for Family Form Builder on our website. But if you just want to access it directly, that is the link right there, www.publiclegalinfo.com/family-law-form-builder. I also have the contact there for Family Justice Services. If you want to learn any more about them, that website there, the court.nl.ca link, that's a great way to learn more about Family Justice Services. I have the phone number for the Avalon region, just because if I had to list every single region, I'd need 3 or 4 slides. And of course, most people who attend our presentations are on the Avalon region. So I have that number there. I apologize if you're in another part of the province, but you can get that number through there. Or if you need to give me a call or send me an email, I'll get that for you. Don't worry about it. Again, reminding everybody, we have a family law guide. It touches on, quite briefly, mind you, but it touches on grandparents' rights specifically, but it talks about these court processes and how you get through the steps as well. And that's the same, more or less, whether you're a parent or a grandparent. We've got some questions coming in. That's great. I'm just going to jump through the last bit here and we'll get on to it. Okay, here we go. It's the perfect opportunity for the questions. So first question we have, where are we? Getting it up on my screen now, it's a tricky part. So the question is, oh yeah. All good, Mary?
Did you see the question in chat?
Yes, I did, yeah.
Yeah.
So we'll start with that one. So can a child actually contribute or ask for representation in the process to access? So great question. And yeah, the child can, again, contribute to the process and the proceedings. It just kind of depends where the child is. If we're talking about a 4-year-old, I mean, they're pretty easy to sway and say, I'm going to give you a new video game, or I'm going to give you candy, or I'm going to give you a toy or something like that. Kids at that age are pretty young, so there's not really a ton we can rationally get from them. So courts are less inclined to have kids involved in that situation. Now, of course, if there was something like you're talking about a mature 8 or 9-year-old who does well in school, and maybe they've gone up a year or something in school or whatever, and they're really mature for their age, the court might want to hear what they have to say. Usually I say it's right around 12 or 13 or so that the court is really interested, because at that point, the child is old enough, they've kind of developed enough to be able to make those reasonable, rational decisions, sometimes not reasonable. They might have rationale for it, might not be the best, but the court wants to know that, if the child doesn't want to be with their stepfather or their mother or whatever, and want to be with Nan or Pop more, the court wants to know that, and they want to make that happen, wants to facilitate that. One thing that kind of comes up, this is a bit of a different tangent to it, is that parents, it's more parents when they're dealing with parenting time and parenting of a 16 or 17-year-old. They want their custody and access parenting time of a 16 or 17-year-old. At that point in time, it's really difficult for a judge because they don't want to force essentially a grown adult to do something they don't want to do. You're still at law a child, but you don't see judges ordering 16 or 17-year-olds to have to go with mom or have to go with dad. So at that point, you're kind of in a bit of a legal gray area. Just to give you some more practical side of it. Again, it depends on the situation. Every case is different because, again, we could have a very immature 16-year-old. Much like you can have a very mature 12-year-old, you can have a very immature 16-year-old. So there's those considerations always, but yes, a child can certainly contribute to the proceedings. Asking for representation, it's a bit of a trickier question, of course. They can have some lawyers for them. It's a bit of a tricky beast, and I don't want to get too deep into it because it is very rule specific, and I wouldn't want to say something wrong, but we can always chat about that if I have the opportunity to look up things in real time. We've got another question coming in here. Great presentation. Thank you very much, Rosa. I'm wondering if you can comment a little on the difference between parent rights and grandparent rights. For example, what are realistic expectations for grandparents in cases where grandparents have not had a role that would be equivalent to a parent? The reality is parents and grandparents are almost identical in terms of rights, because again, we got to think about it as rights of the child, not rights of the adults, right? We're thinking about the best interest principle as our guiding factor. Sometimes that means the grandparent is the one that we're favoring. Sometimes that means we're favoring the parent. Sometimes it means we're favoring one parent over the other. All comes down to what is best for the child. So it's a tricky beast. In terms of differences, it's kind of hard to say. You can get into nitty-gritty case law on some of these things, but really, again, it's going to be case specific. And there's going to be times where it's more beneficial for a child to be solely with a grandparent versus solely with a parent. If the parent is, again, a recovering drug addict who has no work and hasn't had a stable home for 6 years, and maybe they have been incarcerated on and off, and they have a peace bond with their mother or their former partner or something like that. All these types of things, they're all considerations. There's a likely chance that maybe the child's been in danger before, where you don't have that with Nan and Pop, because Nan and Pop are, they got a home around the bay, they've never had any of these issues. They can provide that stable environment. So it really depends. And it can certainly go the other way. You can certainly have the alcoholic grandparent. So that question, it's a great question. Are there much in the way of differences? I'm going to say there's less different than you think there is. I think it's the best way to answer that. But again, keep in mind, best interest principle is the key thing, and it's a case-by-case basis. We do have another question coming in. I just want to jump to quickly the other questions as well, just so folks are getting good, even. I don't want people to think just because they're asking a question in real time, they'll get asked more quickly or something like that. I'm going to stop sharing on my end. Everybody can get a chance to see everybody here now. One of the submitted questions, do I have the right to see my grandchildren? Again, it comes down to the right of the child. I think it's the key thing we're looking at there. And yes, of course, the child has the right to see the grandparent. It's just a matter of is that in best interest. Next question on the submitted ones, and I'll answer the one online that we just had come in. If a grandparent is a child care provider but unpaid, what are the legal rights? So whether you're paid or not, it's not really a factor that we look at, whether favorably or less favorably. Certainly, though, if a grandparent is providing childcare, Monday through Friday, 9 to 5, while the parents are working or something like that, that's going to be a factor. I mean, that's again, that's a stable home environment. That's someone who's close to the child, who knows the child's needs. So those are considerations that court would certainly take into consideration. Again, best interest. Well, I've watched the child grow up. I've reared the child essentially. So that's important too. Just go back to the live question we had here. Just chat. Okay, so courts generally don't want to put any child on the stand and ask this to pick between parents and grandparents. Very true. Courts don't tend to put children on the stand at all. Of course, it's a bit different if they tend to be at 16 or 17, but again, at that point, you usually don't see those children being involved in court proceedings anyways. Where their views can be reasonably ascertained often means a report from a counselor. Yes, so this is alluding to the Children's Law Act, saying where their views, the children's views, can be reasonably ascertained, refers to a report from a counselor. True and not true at the same time, because of course you can have situations where a child is able to provide something to a judge, depending on what the situation is. I've seen that happen. There might not be a counselor involved as well. So it kind of can go, it can go really almost anywhere sometimes. But most typically, it tends to be a report from a counselor. And if we're talking about child protection, which is a different beast altogether, we won't touch on any of that. Certainly then social workers, counselors will be involved in those situations. So that's a great point to bring up. Next question. If my son is a child, but my daughter-in-law has a sour taste for allowing me access to the child, what are my rights? I mean, again, I think a lot of these questions you would kind of answer in a lot of ways. But of course, if two people have a spat, it kind of again comes down to that child. What's in the best interest of the child? We're thinking of the rights as the rights of the child as opposed to the rights of the adult, right? So it's a different shift. Next question is, if my grandchild was born into a common law relationship, and we have a presentation on common law because it kind of doesn't really exist in Newfoundland and Labrador. That's a whole other beast. It exists at a federal level and in like some very specific situations, but common law doesn't really exist, kind of like people think it do. So a grandchild was born into, I'll say, an unmarried relationship, which is broken down. Do I have any rights or access and anything else if the child, if he or she is with a parent who's of no relation? Again, yeah, when we looked at that Children's Law Act, it provides for the grandparent to have access, parenting time, that kind of stuff. So certainly that is a possibility. If a parent is refusing a grandparent visitation as they have sole custody of the child, what are the rights, if any? Again, we know the answer here. If the rights are of the child, we can certainly get that there. Question is, how do you actually execute those rights? And unfortunately, sometimes unless you can resolve it outside of court, sometimes that means going through court. That's not possible. So keep that in mind. Again, folks, please feel free to ask questions in the chat there. I got a few more to get through here as well. If my daughter lives out of province, can I request the child spend time with me in another province? That's a tricky one. Yeah, you can, but this is definitely beyond the presentation today, but we're looking at interjurisdictional orders, which is a tricky beast. That's a whole other kettle of fish we won't get into. Do I have a right to having the child visit? Does the parent have to agree? See, the thing is the parent doesn't have to do anything with the grandparent, right? Until there's court order, of course. So until there's that court order, no, they don't have to send the child to Toronto or Montreal or whatever, wherever. And again, if you do end up with those court orders or those separation agreements, or not separation, sorry, those parenting plans and those sorts of things, facilitation can be a bit of a tricky question on its own right. I've not seen my three grandchildren in the last 5 years. That is unfortunate. I'm sorry to hear that. What are my rights concerning me visiting them? Yeah, I mean, one of the things with this, again, and I always like to touch on the practical side versus the legal side of it, because the law is always in the background. But again, if people are doing whatever they want to do, and there's no issue, and the court doesn't have to come in, that's fine. So if you have a grandchild that's 16 that wants to come visit you, again, as I said, I mean, I'm not saying that this is what you should do or urge the child to do. A 16-year-old wants to visit you for 20 minutes on Friday afternoon. they're pretty much an adult at that point. It's kind of up to them. Again, a court could order something different, but it's less common. Now, of course, if there are 10-year-olds, those types of situations, of course, it's best to work out something with the parents. And I think that's more on the practical side, just not burning any more bridges, creating any more trouble for the children. Again, kids, they might be in another room, but they certainly put their ear to the door and listen to what Nan and Mom are screaming about, right? So I think that's a reality we have to all consider. Can grandparents apply for custody of grandchild if they feel it's not being properly cared for? As we saw, of course, yes, the grandparents can apply for custody, parenting, access, all that kind of stuff. Grandparents can apply for 100%. Not so common. I've seen it happen. Again, you got to consider the best interest. If you have, maybe there's only one parent in the situation, let's just say the other one's not known or something like that, something's happened. Maybe that one particular parent isn't doing a great job. And it is appropriate for the grandparent to step in and say, look, I'm able to care for my grandchild. They know me. This is probably a good thing because we've done it before or something like that. So you certainly can apply for that. Take a look, and again, don't feel shy to submit any more questions on the chat. I still have a few more, so it's all good.
All the questions you had, Greg, are they all responded to now?
Almost. We are on 9 of 13, so we have a few more, and then all the ones that have come into the chat we've gotten. So again, feel free to ask more in the chat, and if you want to speak it out loud, that's fine too. I'm okay with that as long as whoever's asking is okay with that.
Anybody?
What, if anything? Oh, no, go ahead, sorry.
Oh, go ahead.
Yeah, no, I was just going to say the next question, and we'll open up generally to the floor then afterwards. Only a few more of these. Would rather be a bit more polite or something like that. What, if anything, can grandparents do in the event they see issues with the care and custody of their grandkids? So there's two things here, well, three things really. We all have a duty as just society, if we're aware of child abuse, for example, and hopefully this isn't what this question is kind of alluding to. Sometimes it is a reality though. If we're aware of a child in need of protection, a child in danger, we have a duty, a legal obligation. It's one of the only few positive obligations that everybody in society has. We have to report that to police. And that's true of me if anybody ever called me and said, I know my grandchild's getting beaten, right? I mean, that's unfortunately something that, although we do everything confidentially, one of those things that we don't have a choice, we have to report. Same thing with an adult in need of protection. So if that's the case, certainly call the police. I mean, at the end of the day, we don't want a child to become another statistic. So that's the first thing, keep that in mind. Otherwise, if these issues are kind of more along the lines of, the child's not going to school and, they're kind of having behavioral issues because, they're not playing sports now, and they're not doing this, and all these kinds of things are going on. Parents are restricting that kind of stuff. You can certainly, as a grandparent, apply to court again, whether that's for some parenting time or what we formally call custody, 50-50 parenting, 60-40, or maybe it's 100%. You can certainly make that application to court. So keep that in mind. Got a question come in here. So will the court consider if a relationship between a grandparent and parent is toxic in making a decision for a grandparent's access to that child? So for example, if there's a great deal of tension between the parties that could potentially hurt the child. Yeah, I mean, again, the courts are going to look at everything, right? Especially as long as it's presented to them, they'll know about it, they can do what they need to. As we saw, there's a number of steps that kind of come along the way. And there's opportunity to kind of bring that up as well and hopefully come to your own resolution. But if that's not possible and you get to that ultimate trial or judgment court order, whether that's at case management or otherwise, a court can consider, they certainly can consider that relationship between grandparent and parent. Again, we're doing everything in light of the best interests of the child. So if it's just, mom and her child, so the grandparent and the mother are bickering every time they go out and seeing each other kind of thing, the kid's not around, and it's not really impacting the child. Maybe that has less of play, but certainly, they will consider that if it is impacting the child. So this is actually a particularly interesting one. So during court, the
judge decided that grandparents' time is included within time already allotted to my biological daughter and not equally shared with the ex-husband's time. So the grandparents' time was being kind of subsumed within the daughter's time, mother. Although we did not get to present our own case, which, depending on what was going on here, that might make sense, because if it was a divorce or something, you probably weren't a party to it anyways. I had to pay with no resolution. Now, that part confuses me. I'm not sure. I've read some of these questions before, so I'm not really sure what was meant by when it says, although we did not get to present our own case, I had to pay with no resolution. Just so everybody knows too, you can message me privately, and again, I won't name it. If anybody says anything to everybody, of course, everybody can see it. But when you go on your chat bar there, you can click specifically to Greg Noseworthy, you'll see me specifically. Nobody else will see what you say, so if anybody wants to add or anything there, you can do that. So I'm not sure what you meant by, although we did not get to present our own case, I had to pay with no resolution. I'm not really sure what that meant. And it continues on. I gave up my time trying to see my granddaughter, as I was told it was up to the parents. Again, as we see, it's not necessarily true. When there's a parenting order, and parenting time is 50-50, say, or 40-60, whatever it is. If parent wants to give the child to the grandparent for 100% of their time, they can do that. This is one thing that frustrates a lot of people after divorces. If time is like, say, Monday through Friday, the child is with the mother, and then Friday, Saturday, Sunday, the weekend essentially with the father, but the father just pawns the child off to their parents, so the grandparents. That can frustrate a lot of people. But the thing is, when you have your custody or parenting time, you can do essentially whatever with the child as long as the child's being taken care of. Again, this is very frustrating for people, but this is kind of where that, grandparenting time can be subsumed within the parenting time of the biological child's mother or father or whatever. So that's a bit of a different one. I got tired of fighting, losing battle. I was under the impression it's been 3 years since I saw her for half an hour. It's unfair. Full question didn't come through. Certainly frustrating, there's no doubt. When we look at court orders, when court orders are actually put forward, if it's not working, you can file for what's called variation. There's, similar to that originating application we looked at, there's also an originating application for variation. Basically, what a variation application is just saying, look, we have a court order, it's not working for me or whatever, we want to change it slightly. So we're putting in here on our application, this is what we want, to change it a little bit, just to see if this will help fix the process. And you'll go through the similar hoops and hurdles as before, but it's a good way to resolve a situation. It's the method to resolve a situation if you can't do it afterwards. So keep that in mind. If there's been a court order and it's not working, it's been 3 years, 3 years usually is a good time for courts where they'll accept a variation application. If it's been a month since your court order, less likely that a court will accept that application, just so you're aware, unless something drastic has changed, like somebody maybe passed away or something. But otherwise, you have that option for variation. Oh, lost my question. How can courts decide to include grandparents' rights into the schedule within the visiting schedule of one parent only? Again, it comes down to the best interest of the child, right? So unfortunately, it's kind of a hard thing for me to answer without full picture, but just generally, courts are going to do what's in the best interest. And, again, if somebody doesn't make an argument before court or actually participate in the proceedings, the court is only aware of one side. So obviously the court's going to be skewed to one side. Judges are, they don't have biases, but at the same time, if you don't present your side, a bias is going to be created because you haven't been able to present the full facts. So keep that in mind. And again, if that's what's happening, you have that option for variation. Do grandparents have any right, or at the end of the day, is it entirely up to the parents? Obviously, we've seen that is not the case. It's not entirely up to the parents. It really comes down to a grandparent making an application or starting to start proceedings. Another thing I didn't note in the presentation, sometimes that means just speaking with a lawyer and getting a lawyer to try and resolve things before you have to go through the court door processes. Obviously, there's a cost there, but I always make a point that, sometimes people don't treat people in their lives seriously. And having a lawyer's name with some letters behind their name can really create that that sense of urgency and seriousness. So sometimes that's a good way to help resolve processes as well, and just be taken more seriously. If anybody needs help getting lawyer, of course, we have that lawyer referral service, the $30, $40 thing. So keep that in mind as well. Last question, and then we'll open it generally to the floor unless there's anything specifically coming in through the chat. This one is, and I don't know how this question was worded, so I'm going to assume that it's we are great grandparents, as in we're good grandparents, but maybe not, maybe we are great grandparents. Either way, hopefully you're great people. What rights do we have to see our grandchildren if the mother says she can keep them from seeing us? So again, this is kind of the enforcement reality. It's like me if I have my cat and I say, Miriam, I know you really want to see Stella, but I'm not going to let you see Stella. I want her just for me. Until you actually bring something before the court, there's no mechanism for you to do anything to get that visitation or that parenting time, that kind of thing. So it comes down to actually bringing something before the court. I think that's the most important thing. So that's it from the submitted questions. If anybody wants to follow up on any of those, please feel free. And again, I always say this, if anybody wants to chat more intimately, or you're a little bit shy or don't want to bring up the question to the group kind of thing, that's okay. You can either do it via direct message to me personally on this, or just give me a call after the fact. I'm going to pull up my slides again here and get my information and such up.
That was great. Greg, that was a lot of information there.
Yeah. Oh, good. I'm glad. And I really appreciate the opportunity to come out. I'm just going to type in the chat for everybody there my email and the phone number, so everybody will have an opportunity to get that.
Actually, you mentioned, made a reference to the different laws between married couples and common law couples. And actually, everybody, while I did not have an opportunity to talk to Greg about that, I was planning to invite him to come back maybe sometime in April and do a session just on that topic.
Love to. Yeah, 100%. I mean, Mary, we did one over the summer. That was great.
Put you on.
Yeah, no, I love doing it. Yeah.
That's lovely. Okay, everybody, you can always get in touch with me or Greg if you have any more questions or anything. And I will be sending out, I don't know why my slides are not working here. I will be sending out my, it's just not doing that for me. It doesn't want to do that for me.
Well, I'll tell you what, Mary, while you're trying to sort that, I'll pull up just quickly so everybody can see it.
That's okay. I just want to let everyone know that next week we are going to have a session on adult protection and capacity. Okay, I don't know if, I know some of you are aware of this, but probably not everybody. But Seniors NL also has a provincial network for the prevention of elder abuse. And they do, affiliated with them, we do sessions on elder abuse or different aspects of elder abuse. So we're going to have the next week's session will be on adult protection and capacity. That's the Adult Protection Act and the whole meaning and around capacity. When people have or do not have capacity. So that will be, that's an exciting thing to look forward to. And I'll be sending out an invitation for that later on today. So stay tuned, everyone. And, keep us in mind and please stay safe. We're almost at the end, I hope, of COVID for now. So just protect yourself and, we'll get through this. Bye, everybody, and thank you. Thanks, Greg.
No problem. Thanks, guys. Take care, everybody.